Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing Amity Treaty companies, and we're discussing them specifically in the context of U.S. taxation and U.S. tax liability. A major question that has arisen, especially with respect to the Tax Cuts and Jobs Act, so-called Trump tax, if you will, is whether or not, well, a question that popped into my mind is what's the tax liability to an Amity company or the owner of an Amity company as a result of the changes to the law with respect to so-called foreign corporations. And many of those who are watching this video may be aware of things like the Global Intangible Low Tax Income regime, so-called GILTI, things like FDII, Foreign Derived Intangible Income, things like the transition tax, etc. Now, all of these came about as a result of the Trump tax, for lack of a better term. That's what I'm going to go ahead and call it, because it was implemented by, or I should say it was promulgated in Trump's administration, passed by Congress under Trump. So we're going to go ahead and label it for the purposes of the rest of this video as so-called Trump tax. Call it Trump tax. So Trump tax created all of these things, and they are of especial concern to those corporations which are deemed controlled foreign corporations by a U.S. person. And a U.S. person may be a company, it may be an individual, etc. But it creates a certain onus with respect to those entities which are considered controlled foreign entities, controlled foreign corporations. Now, most folks have gotten into the nitty-gritty, and we have too, with respect to certain aspects of our advisory practice here, but most folks have gotten down to the nitty-gritty with respect to things like calculating the GILTI formula, or calculating formula related to things like erosion of the corporate base, etc. Those types of analyses are very good and I think very necessary, but I happened upon something that, in my mind, really goes to the core of an issue of the entire issue with respect especially to Amity companies here in the kingdom, and I wanted to go ahead and share it in this video. Now, I've gone over this multiple different times. I am licensed in the United States, including in the U.S. Tax Court, and I have studied this pretty well at length. It should be noted that specifically this does not necessarily deal with analysis directly of Trump tax and the provisions of that newly promulgated law, or recently promulgated law, I should say, but it does go to the heart of the matter as to whether or not the new provisions even apply to an Amity company here in Thailand. And the reason I bring this up is because most folks are looking at issues like control or the formula for dictating taxation. My question was immediately, or shortly after sort of diving into this, and I've done a really deep dive into this in the past months, so my question being whether or not Amity companies, so for those who are unaware, in the Kingdom of Thailand, Thailand and the United States share the U.S.-Thai Treaty of Amity, and the U.S.-Thai Treaty of Amity basically dictates certain provisions and certain privileges, immunities, and benefits that are granted to the citizens of both parties, namely Thailand and the U.S., when doing business in each other's jurisdictions. So one of the major benefits to Americans operating in the kingdom, including American companies, is so-called national treatment. And national treatment provides the same treatment as, treatment as, for example, Thai nationals doing business in Thailand. It provides those same protections to American businesses. Now, that's about as far as I'm going to go with respect to analysis of how that pertains to Thailand. But a major question that it was vexing me greatly, and it still does in many ways, pertains to U.S. taxes. And before we proceed with any tax analysis, I want to go ahead and preface it with this. This should not be viewed as definitive tax advice for specific circumstances. This is for informational purposes only, and quite frankly, I'm kind of speaking out loud. This is me posing questions and interesting aspects of the law, but it should not be viewed as a definitive legal opinion regarding the tax situation as it stands, nor on any one specific tax situation, nor tax advice pertaining thereto. So do not look at this video as anything other than informational and should not be viewed as definitive and should not be relied upon when making your own personal decisions with respect to your own tax filings. So, as I stated, what we've been looking at is the ramifications of Trump tax. Again, GILTI, FDII, things like the transition tax, etc. And a question came to my mind when I was looking at the regs and the law itself, which it deals with controlled foreign corporations. And that got me thinking, because I said, well, what's a foreign corporation? Rather than worrying about control or the formulas associated with the implementation of these new tax codes, my question was, are these companies foreign? So I went ahead and looked it up, and I found, according to 26 U.S. Code 7701A5, the term foreign is defined as, and I'm quoting here, the term foreign, when applied to a corporation or partnership, means a corporation or partnership which is not domestic. So a foreign corporation is defined in the negative. You have to determine what a domestic corporation is in order to determine what a foreign corporation is. So I went over and looked at 26 U.S. Code 7701A4. The term domestic is defined as, and I'm quoting, the term domestic when applied to a corporation or partnership means created or organized in the United States or under the law of the United States or of any state, unless in the case of a partnership the secretary provides otherwise by regulations. So I'm going to go back and paraphrase this here in a moment, but I want to go ahead and also quote directly from the IRS website, that's irs.gov, quoting directly, a corporation created or organized in the United States or under the law of the United States or of any state or the District of Columbia. That's the definition of a domestic corporation. So, I want to go back and paraphrase this now from 7701A4. The term domestic, when applied to a corporation, means created or organized under the law of the United States. So I'm paraphrasing for what we're specifically talking about here. So, a corporation created or organized under the law of the United States. Sounds pretty simple, right? Created or organized under the law of the United States. So, moving forward, the U.S.-Thai Treaty of Amity is a treaty. It was ratified by the Senate by, I believe, 69 to 31 votes in the year 1969, and it was promulgated by the President of the United States. At the time Lyndon Johnson promulgated it, it was ultimately ratified in 1969. Now, Article 2 of the U.S. Constitution states that the President shall have power by and with the advice and consent of the Senate to make treaties provided 2/3 of the senators present concur. Now, it doesn't actually say it has to be what we call ratified, but it just says upon advice and consent. And it's well known that a majority vote in the Senate to confirm a treaty, to ratify a treaty, that's clearly they've advised and consented on the treaty. So the President promulgates, the Senate advises, and then consents, in this case 69 to 31, back in the year 1969, and the treaty is then ratified. Okay? So, further, under Article 6 of the United States Constitution, which is sometimes referred to as the Supremacy Clause, it reads thusly: this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. Okay? So let me go back and just get to the salient point here. All treaties made shall be the supreme law of the land. Okay? So let's go back to the term domestic. Again, 26 U.S. Code 7701A4, the term domestic, when applied to a corporation, means created or organized under the law of the United States. Pursuant to Article 6 of the United States Constitution, the ratified U.S.-Thai Treaty of Amity is United States law. It's the supreme law of the land due to its ratification, the fact that it is a treaty. And it is my opinion that companies created or organized under that treaty are, notwithstanding the fact that they're in Thailand, domestic corporations pursuant to the definition under 26 U.S. Code 7701A4 because they were created and/or organized under the law of the United States, namely the Amity Treaty. And most notable there is you need to keep in mind, the viewers should keep in mind, that pursuant to Thai law, and specifically the Foreign Business Act here in the Kingdom, in most cases of foreign ownership of Thai companies, there has to be a minority ownership by foreign nationals. But pursuant to the provisions of the treaty, and we've gone into that at length in other videos, pursuant to the provisions of the treaty, due to the national treatment granted under the terms of the treaty, the company here in Thailand would be organized in a different way. In fact, it would be created in a different way for that matter too. But in either case, but for the treaty, Americans would have to operate under the Foreign Business Act. But thanks to the treaty, which is U.S. law pursuant to Article 6 of the U.S. Constitution, thanks to the treaty, American Amity companies enjoy different benefits and a different type of certification here in the Kingdom in order to operate. And they are definitely created and or organized, depending on the circumstances of the company, under U.S. law. And therefore, in my opinion, these companies could be considered domestic corporations and therefore not subject to certain provisions of so-called Trump tax due to the fact that they are controlled domestic corporations, not controlled foreign corporations, notwithstanding the fact that they may be legal entities in another country and may be physically present in another country. Treaty law, the law that allows them to be organized in the way in which they are, creates the domesticity element, if you will, because treaty law is United States law. I should say specifically, the U.S.-Thai Treaty of Amity is United States law pursuant to Article 6 of the United States Constitution, also known as the Supremacy Clause. We hope you found this video insightful. For those of you who are interested, we're trying to make videos to provide up-to-date information as soon as this information comes out. And for that reason, it may be a good idea to go ahead and click the bell button, the bell icon below, to go ahead and be updated as these videos come out, as you can go ahead and be apprised of the legal situation as it evolves.